Welcome to part 3 of our series Legal Drafting. Today we are going to talk about a critical skill in our appellate practice, and that is drafting grounds of appeal. Whether you're appearing before the High Court on appeal from the Magistrate Court or before the Court of Appeal, the quality of your grounds of appeal will determine whether the appeal succeeds or not. First, what is a ground of appeal or grounds of appeal? A ground of appeal is a concise and precise statement of the error that the lower court is alleged to have committed. And this error may be an error on the law, facts, or a mixture of both the law and facts. It may also be a procedural irregularity that goes to the jurisdiction of the court to entertain the suit. Grounds of appeal are not a summary of the facts of your case, and neither are they a repetition of the arguments you advanced before the trial court. The most common mistake that we make is storytelling. For instance, someone may draft a ground of appeal as follows. The learned magistrate erred in facts and law by failing to consider that the plaintiff had tendered a receipt dated such and such a date. That is a factual narrative. The proper ground should read as follows. The learned magistrate erred in facts and law by failing to consider documentary evidence on record, thereby arriving at a finding unsupported by evidence. Do you see the difference? The first is a narrative. The second identifies the specific error. The other common mistake is bundling multiple issues in a single ground. You may come across grounds of appeal that run, let's say, half a page, listing like six grounds that address separate issues, but those grounds are just separated by semicolons. Now, if you have 6 grounds, then you must list them separately. If you list them in a single ground and just separate them by semicolons, then it becomes difficult for even the respondent to respond or even for the court to analyze each issue. And the risk is that if a part of that composite ground is vague or unsubstantiated, the court may dismiss the entire ground. Now, this brings me to the issue of vague grounds. A ground that says the judgment is against the weight of the evidence or the decision was unreasonable is with respect dangerous. In fact, it tells the court nothing. There's nothing you've said. A proper ground must state how the lower court erred. For example, the learned magistrate erred in law by misinterpreting Section 107 of the Evidence Act, thereby placing the burden of proof on the appellant on an issue that the respondent was statutorily required to prove. Another area fraught with problems is failing to distinguish between a mere disagreement and a demonstrable error. Not every decision that you dislike is appellable. The lower court or the judicial officer is entitled to his own assessment of the evidence and can exercise discretion as long as he is within the law. So as you draft your grounds of appeal, ensure that they point towards a misdirection, misapplication of a legal principle, failure to consider a material issue, or consideration of irrelevant matters. If you're simply unhappy with the decision, then you clearly have no grounds. To avoid the temptation of drafting your grounds of appeal in the heat of disappointment, take your time once the judgment is delivered to read it. Read as many times as you can. Take a toothpick and read word by word. identify the ratio decedentile. Remember, your grounds of appeal are the foundation of your appeal, and if they are shaky, the appeal is bound to collapse. For more on law and life, subscribe to my YouTube channel, Beyond the Brief.